Tankha. Tankha.
Thank you for giving me this opportunity. Mr. Finance Minister, I may be new to this House, but possibly I'm not new to the field of law. So there was a comment made earlier that I'm new to this House and this when somebody with 17 years experience, but let me say something about the law part.
That's only a friendly comment by your friend in the court.
Yes.
Yeah, that also he said.
Yes. Now, the point I'm making today is threefold. I'm going to talk a little about DRT, and most of those things must be in your knowledge because these are matters which bar associations have taken up with the Finance Ministry. I'm going to speak about a little bit of Securitization Act and the role of the Reserve Bank. Three issues which I would commend to your to yourself, because maybe it's some improvement in the times ahead would be good for the system. First point I want to say about the DRT is, we have power to take resignations, accept resignations. We have power to remove them, but you don't have power to transfer them. This has been an issue in the past. I'm personally aware also. It has traveled to High Court, Supreme Court, representations. Sometimes these presiding officers have problems in a particular place, and they can't be transferred under the law. So they have to either be removed, or they have to resign, or if they decide to stay, there's a stalemate with the bar, and then it's a non-functional DRT. I'm personally aware, that's why I'm telling you this also. Number two, this situation may have been some days back, but some days back, out of the 5 DRATs, 4 didn't have chairman. These are operational issues. 4 didn't have chairman. I don't know the situation today, it may have improved. But we must ensure that these authorities and appellate bodies have full composition if we want our systems to work well. Third, there was a PIL in Supreme Court in which I was the Additional Solicitor General at that time, I was appearing at that time, in which various directions had to be given that please improve the infrastructure of the DRTs. Some of the DRTs even today are in appalling condition. Pursuant to the directions of Supreme Court, improvements were made in Delhi, for instance, and we shifted them to a new building. Now, in government, you have no provisions for maintenance. So this DRT is on 4th floor. You please ask the lawyers. Half the time the lifts are not working. You have to climb up 4 floors with your bastas. And that reduces your efficiency and reduces the arguments and the seriousness with which we can deal with that, be present in the court. I am also told, subject to correction, that whatever was the staffing patterns of the DRTs in 1993, those staffing patterns are the same today. In the meantime, you have overloaded them with Securitization Act. Now some part of insolvency proceedings would also come there. So the staff number is the same. There's no increase in staff. There has to be augmentation of staff also. This is a standing problem there. The number of cases are going up. Today it is, the pendency is 70,000. If with the present strength we only do these cases, it will take 7 to 10 years to finish these present cases. I'm not talking of new filings at all. So here again, more hands have to be created. A huge issue which has arisen was before the Supreme Court also. Some of our officers, especially recovery officers, are bankers, are railway employees, are employees from deputation from various departments. Now, intricate issues of law are argued before recovery officers. The fact is that they are not able to decipher the argument, and then it leads to delay, it leads to bad judgments, it leads to appeals, revisions, writ petitions, SLPs. Another amendment which has been brought this time was that if you necessarily have to deposit minimum 25%. Earlier, it was 75%, but at the discretion of court, it could be waived. Now, I know for certain there are many hard cases where people cannot deposit, and yet these are good cases. If we make deposit compulsory, you actually are denying opportunity to a lot of people to approach the appellate tribunal. Somewhere the constitutionality of this provision will come in question in those hard cases, and somewhere sometimes, like I saw in Sales Tax Act, we had similar provisions. Then the court stepped in and said, no, in hard cases, you can pass some orders, giving relief maybe under 226 if they don't have the power. Banking industry is a separate subject. It's not a subject today. This is recovery. Banking industry needs to be improved correspondingly, because unless the way loans are granted, the diversification takes place, money laundering takes place after that, all that is now a reality, and most of the high net people indulge in that rampantly. So that issue is a separate issue, but that also leads to more cases before the DRT and ADRT. I would also like to point out that somewhere the Honorable Finance Minister may like to regroup the tribunals. Now, the securitization, money laundering and DRT are closely interrelated very often. Maybe the same same judge can do all three. It may commend your thought process. Again, another point that we notice in these laws is that in the DRT, the bank's branch is not the jurisdiction, it's the defendant's address. If I have borrowed loan, say in Delhi, and I live in Guwahati, you will have to go to Guwahati to file a case, but when in fact it should be Delhi, where you have borrowed. So it becomes easier for the bank then to approach the court in where it's located. So the branch of the bank where you've accepted the loan should be the place of the jurisdiction also. There is an imminent requirement to publish data bank-wise, and also to make a registry of all assets under litigation. The present bill, while providing for certain steps to further the e-governance, completely fails to address the due disclosure and full information to prospective buyers regarding stressed assets, bank recovery, performance, etc., which are vital parameters in debt credit industry. So these are some of the issues which I wanted to highlight, which may need comment improvement in the DRT setup, because without these improvements, you will not get the results which the government desires or the country desires. On the Securitization Act, there are just one or two brief points. 13.2 came under challenge before Supreme Court in Bandia Chemical, and that opportunity part came in, and that's 13.4. Now, after 13.4 is taken as a paper possession. It's not an actual possession. That is why 14 was brought in. And in 14, we've given the jurisdiction to district magistrates and CMMs. I'm sure, and this whole house would be sure, the DMs and the CMMs have no time for these cases. If we actually go and see there, it's the PAs who decide these cases. It should be given, this power also should be given into more responsible hands who know the subject, who know the field, and who are willing to look at the applications with the data and the affidavit in a way that it should be seen. Recently, there's a judgment of Supreme Court in Standard Chartered Bank case, where 14 now has created new problems. In the judgment of Supreme Court, unless your possession, you hand over possession, you can't go to court. You can't go to the tribunal. Now the problem is, an honest man, there could be an order against even a good person. Now, if I have a house, I've not been able to pay my installments, and I may be in a position to do it a little later, or some other reason, I have to first vacate that house, then go. It's only multiplying problems. So somewhere the appeal should come before you are asked to vacate. The law would need to be amended, or the Supreme Court judgment will have to be clarified in the context of 14. The last point that I wish to make, because I don't want to go into details of each section or each, is that please, you've given too much power to RBI. you've involved RBI too much with the ARCs. ARC is a body, you only have 14 ARCs in India today. It should be much more. It's such a regulated industry that you people don't want, not many people can come. Most of the ARCs are through public institutions, created by public institutions. We have given 100% FDI and we want to regulate it. The two cannot go together. They are not in sync. You have to give them a little more liberty, but what are they doing? Actually, they are buying stressed assets and then taking it to the market or as per law, trying to recover maximum out of it. If in this process, RBI at every stage, you know, there's a provision where RBI can even cancel their registration. Now, if the registration gets cancelled, which foreign investors go to invest? And in India, in the past, we have seen how courts have interfered. They have cancelled licenses. They have cancelled after 20 years, 15 years, which has had a very bad effect on the foreign investor. So if you want FDI in this sector, you will have to liberalize the ARCs working, make them more, they have to be market friendly, and also ensure that, of course, accounting, auditing, inspection, all that can be there, but certainly not that you keep them under the clutches of RBI through guidelines, through directions. There's so many sections. I can just read out those sections, but there's no point. I'm just flagging these points. So my whole thing is that reduce RBI's control, improve and operationalize your DRTs and ARTs, and that may give better results. And for that, many bar associations have also made representations to the Finance Ministry. All these points you would also find in those representations.
Okay.
Thank you, sir.
Thank you.